Welcome. My name is Andrew Manko. I'm currently the president of the Young Lawyers section of the Tallahassee Bar Association. And on behalf of the Young Lawyers section and Legal Aid Foundation of the Tallahassee Bar Association, along with two of our sponsors, TBA and Lexus, which I will introduce Brad in a minute just to say a couple words. I want to welcome you all here. Thank you so much. This is the first joint CLE that the Young Lawyers section and Legal Aid Foundation have put on together, and we hope to put more of these on, kind of help younger and more senior lawyers get a little bit more comfortable with taking pro bono cases. So that's really the point, and I'm so glad we had such a good turnout to our first event. So look forward to some more information in the coming months as we develop our second one, which I think we may try and do something on wills and trusts, which is also a common area for family law cases. So I'm going to quickly introduce our panel and then let Brad come up for just a second. But we're very lucky today to have all of the family law judges on the circuit here today. So starting at the end, Judge Martin Fitzpatrick. We've got Judge Barbara Hobbs, Judge Angela Dempsey. Judge Karen Gievers has a prior commitment. She's going to try and make it, so hopefully she'll be able to sneak in at some point here before we're done. And we also have Sid Bigham, who is the current president of the Legal Aid Foundation here. So, wealth of knowledge. We also have our moderator, Sean Desmond. His bio is lengthy. He was the president of the Young Lawyers Division several years ago, and we're happy to have him moderate this panel. So, Brad, if you want to come up from Lexus and say a word or two, and then we'll get started.
I know, it's like...
Well, you know, I'm the local rep around here. I know some of you all, but it used to be, you know, we go to these things for our legal research, right? Statutes and cases are all in print, so I wanted to bring a set of, this is a Matthew Bender, Florida Family Law. This is like your Bible for family law in the state of Florida. Been around for years, and from Brenda Abrams, top lawyers around the state have written it. So I thought I'd bring a set if you want to afterwards take a look at it. I have some flyers, my cards and stuff. But most of the time, attorneys are getting this online, not in print, but a lot of my firms still have it in print because they want to grab the books and check it out. But it's everything, every topic has ever been sort of wrestled with in family law. There's a case on it, there's some backup behind it, there's a topic on it, it's in these books. So instead of reading a bunch of cases to figure out some simple answer in the law, go to here, get an answer. It'll refer you to the leading case, the leading statute, and then you've got your answer, right? So that's what this is good for. So anyway, I'll be in the back.
Thank you, Brad.
Thank you.
I told Andrew, let's make sure we let Brad come up and say something because we keep asking him for money. we need him to have some time, but that's hopefully so you'll switch over to Lexus and help him out. First thing I want to mention was the reference number. This is going to get you an hour of CLE. This is 130-8858N. So if anyone needs that or wants this information, I have it up here. Okay, so when I was approached, I guess back in the spring about maybe helping do this, and the idea was, well, do we do kind of like a seminar type thing? How do we do this? And we decided it would be way better to try and get the judges up here because, you know, I don't know really a lecture type of setting is really what anyone wants. And I'm really encouraged because as I look out, I see a lot of new faces, a lot of younger lawyers, but I also see some very seasoned and experienced lawyers here that really could teach me a lot about family law. So, and I know that, thank you, Viv. But she's taught me a few things this week. But in any case, just having everybody here is really an amazing thing. And I think it's because we have the judges here. And the idea that started to come around was, let's see if we could get all of the sitting family law judges right now. And let's just get them in a room and let's have a conversation with them. It doesn't happen often, and this is a huge opportunity. So I'm going to ask a few questions that were written and that should help us get along. But at the same time, we've got some people in this room that really may have some great questions, and I do not want to shut it down and make it a situation where we're talking at you. I really love it to be a little bit interactive, if that's okay with you guys.
Definitely.
Sure.
Okay. So really, we have kind of broken it up for a suggestion to say that this is really going to be about, Family Law 101 in Leon County and a question and answer. So just to start us off with a couple softballs, I will start with the first one, which is designed
That's great.
for the brand new. I'll just start off with, what are the most common family law disputes that you hear? Are the litigants usually represented by counsel? Let's talk about just entry-level stuff.
I mean, the normal practice is if there's no counsel involved, if they're both pro se, they would normally go down to the magistrate judge, at least initially. If they object to jurisdiction, obviously we have to take it back. And that's kind of intended so that the magistrate judges are more set up to educate folks that don't know the law, who are representing themselves, to try to walk them through that process a little bit better. It's tougher when you're sitting up there as the judge to kind of handhold a pro se person who is really coming to fight about wanting their kids back or something like that, and walk them through the process. So if it's two pro se folks, they'll usually go down to the magistrate judge first. If there's a lawyer involved, normally we would keep the case and resolve it, but we've done it both ways, where there's one pro se and one lawyer, then send it back down to. But normally the cases that come up are two lawyers involved, although I've had several where it was pro se, and usually what it is, they don't have money, they don't have assets, so they're fighting over splitting up the debt. But the toughest issues are the parenting issues, which those cases always have, and walking through with the folks and helping them to understand that, well, I can make a decision regarding whether you have your child on Tuesday or Wednesday. It's probably better for you and your soon-to-be ex-wife to get together and try to work out that issue yourselves, because I can impose a schedule on you, but no one that leaves is going to be getting 100% of what they're asking for. So that's probably from the pro se's perspective, it's mostly the parenting issues that we have to deal with, because you're not splitting up hundreds of thousands of dollars. You're splitting up who's going to have the kids on school nights, that kind of stuff. So
What kind of advice would you give lawyers handling a case where there is a pro se litigant on the other side, and how do what can you say about that? Any one of you.
I guess I would say don't look like you're beating up on the person that much, and try to work with them like you would someone that was represented, although sometimes that can be difficult depending on how difficult the litigant is. I've got a couple doozies in front of me right now. We usually refer the ones where it's just one side represented to the magistrate too. And in general, Magistrate Ace Pedroso is paired up with me, so he'll usually get my pro se cases, and Gordon Scher is paired up with Judge Hobbs and Judge Fitzpatrick. And in general, they do a great job. And you guys probably know you have 10 days to object to them hearing the case. And then after they hear it, you can file exceptions. And then that would come back before us, like in an appellate capacity.
yeah, and I think that's something to make sure you all understand, is when you do file those exceptions, I'm not going to hear the case over from the beginning. When you file those exceptions, it's akin to an appellate sort of procedure where I'm reviewing what he's done already. I'm not going to have you re-argue everything from square one. It's going to be, what did that magistrate judge legally do wrong and why? I'm not going to resolve, again, disputes of fact. So it's a different road that you're going down than if you're just, in say a mediation falls through. It's not the same thing as a mediation at all. The magistrate judge is making findings that are going to be binding on you going forward. And I've had a couple of those pro se cases where, they schedule them for an hour, and then all of a sudden it's 2.5 hours later, and I'm finally saying, no, you understand, you're going into issues that you didn't present to the magistrate judge, so those things are fine and dandy, but they're not going to affect the outcome here. So it's something to remember when you're going through that process.
The thing that I would advise lawyers dealing with pro se litigants is that trying to tie them down with notices. Get some really good addresses and emails, and if you're smart, you would email them and email the court, because I have a lot of litigants, pro se litigants, I didn't get that judge, and so tying down those notices is really important, and making sure that the pro se folks get it, or you have evidence that you sent it. That has been a problem lately for me, is people saying, I didn't get your notice, they never sent that to me, you signed that order and I never saw it, that kind of thing.
Sid?
Well, the question, or the issues that I've seen come up being a lawyer, where you've got a pro se litigant on the other side, the biggest thing is just that they think they know what they are after, but they don't understand the law. And so it may be a situation where somebody's asking, you're trying to negotiate an arrangement, and somebody's asking you for something that's just not feasible under the law, or something that isn't at issue in that particular case. And that can be a challenge a little bit to explain it to some of these folks, especially with all the emotions that can be involved in a family law case. But I would just recommend keeping your calm and being very civil to the other individual. You got to remember the level of stress that they're under in these types of situations. And if it comes down to it, just communicate with them in writing. That's a good solution for an especially difficult pro se litigant.
And let me ask, if every one of y'all could be thinking in your mind one question, okay? Because I might pick on some people and I don't want to do it cold. Just be aware that if I know you, I might ask you a question. But seriously, and I want to kind of throw it out there, because I personally have, in that situation with the notices, I get nervous sometimes about, well, they're going to say that they haven't been properly noticed. And I've actually gone ahead and gotten them served with the notice of final hearing, even though I've already gotten them served. Has anyone ever done that? Do you recommend that?
Absolutely, it's in the rules.
Okay. Well, let's talk about that.
Yes, that's what I do, and that's what the rule says. If you have a default or a non-answer or whatever, you have to serve the notice of final hearing on the one that hasn't participated so far.
I think you meant service of process though, right?
Yes.
I do, I serve it.
Okay.
But that's what it says, serve. It doesn't say.
Well,
I
if they
think the
haven't-
rules don't mean serve through mail would be sufficient.
Well, but if they haven't made an appearance yet, that's the problem, I think.
So, and really, the question to me is of best practices, and really for you guys, do you recommend doing something like that, or do you think, Judge Hobbs?
Yes, and I'm not just talking about process, if you have a motion to modify parenting, the mother doesn't show up, she doesn't, as Gordon says, she doesn't put in the game, and then you do something and she's calling and writing all kinds of things about, I didn't know, I wasn't put on notice that you were going to do this. And it's not just process I'm talking about just your modification motions, or a lot of different, just simple motions. Litigants that come in and they swear they've never seen it before, they don't know, they didn't know, and sometimes they do.
And probably the bigger change you're making, the more important it is. Like if you're terminating someone's rights or making a major change in their time sharing, then I probably would pay the extra money.
So as like a matter of
Order to
best
show
practices.
cause, things like that, I never got that.
Well, I'm going to require you to show me what you've done, so the more you've done, the better you are, the better off you are. So.
Okay. Let me ask this. What, in your time on the bench, have you seen as the most common mistakes that young lawyers are making, or lawyers in general, that are maybe taking family law cases that aren't doing a lot of family law? What's some of the mistakes you see?
I guess I'll start. Lately, we've been having a lot of people just not show up for mediation, or not schedule mediation and not comply with the mediation order. And I've been issuing orders to show cause why the case shouldn't be dismissed. So even if you guys are like informally trying to work the case out, I mean, all you have to do is basically keep us apprised of what's going on. I don't think it's ever a good idea to ignore a court order, but that happens more frequently than you would think. And then maybe just not being as familiar with the rules as you should be, the family law rules. It seems like the rules of procedure are changing so frequently lately, too, that you got to keep up to date on those changes.
I didn't think about that one.
Well, I think one of the issues that, I've had several hearings where the parties come in and say, we've agreed to all the issues on property. And then the evidence starts coming in and, well, I said it was 17,000, but really it's 22,000. And, well, that was really not marital property. That was something, if you're going to have a stipulation where you guys say you have an agreement, let's put it in writing so that we know what the stipulation is before we proceed with the case. Because I get, at the end of the trial, I get these briefs from both sides, these memos from both sides or proposed orders. And it's funny because they'll both say the same thing. The parties agreed to these issues. The parties agreed to these issues. But then I look at these distribution schedules with assets listed and they're different. So I have to go back then and say, I've got notes here. What do I think about this debt or this piece of property, or how do I come to that number? I can do it. But if you all have a stipulation about it, put it in writing, sign it, so that when you walk into court on the day of the trial, you can hand it to me and they say, this is the schedule of assets and liabilities, and we are in agreement as to that. So there's no question later on in the trial what the issues are. So
That'll save everybody time later.
it's hard to rebuild the evidence from my handwritten notes and the disagreement between the two parties on what the issues are. So I can do it, but it's, it takes more time, and it's not always perfect. So
I don't know. I guess I'm getting a slew of old lawyers because most of my lawyers are very experienced. I don't think I've had very many young lawyers, and coming from the criminal offense bar, and basically was totally unfamiliar with domestic relation type cases. I have really enjoyed the lawyers that have come in front of me because they don't have a problem with saying, I don't know, Judge Hobbs. They're very bright. They're very well. I don't have any complaints about the lawyers that have been appearing in front of me in the last year.
Great. Well, obviously, Sid, you're here, and one of the things we're trying to do, in addition to putting you guys up here and having a chance for us to talk to you, is encourage more people to take pro bono work, right? As you know, the Tallahassee Bar did away with its pro bono requirement, and there was a big celebration in the streets, but at the same time, we have a serious problem, don't we, Sid?
We do. Volunteerism rates are down significantly, on the order of 70%. The waiting list is long, and there are families in the community that could really use all of our help. It's a community health issue, really, if you start to think about the intangibles, the effects of a child not being in a safe home, or not being with the proper parent, not being with somebody who can help them, and give them a safe environment and give them the support that they need to get through school. That can be the difference in a child's life, whether they end up being successful and a productive member of society or incarcerated. And so I think the intangible costs to society are incalculable, and it's something that affects every single one of us. I think that the attorneys owe a duty to this wonderful community to make sure that those individuals are properly taken care of.
I do see quite a bit of young lawyers. Next time, speak up a little bit more.
Okay.
I do see a lot of younger lawyers out there that I'm just meeting now, but I'm hearing from Judge Hobbs that not as many of them are venturing into court. Is that the same for you all?
apparently Judge Hobbs sent me all of her cases involving the young lawyers. No, I have both. I've got lawyers that have been practicing for decades, and then I've got lawyers that are younger lawyers.
I think I have a mix. One really good thing about family law is if you haven't done a certain pleading or judgment or what have you, there's the forms on the Supreme Court website
Yeah.
that you can, at a minimum, start with, and then go from there. Those are really, really helpful. Like, I use those in pro se cases, or sometimes even if it's a lawyer that's not as experienced in family law, or there's some particular issue that I think is important, I'll bring those with me to the hearing and just kind of make sure, like, there's nothing we missed, or those are really helpful.
That is a good starting point. And the books that we have over there from Lexis are really good. I don't know if you guys,
Family law books.
I guess you guys probably don't know this, but I wasn't a family law litigator either. I did commercial litigation, so it's a little bit different, but it's a little bit different.
We entitled this program An Invitation to Family Law for a reason, and it's really, obviously, I think we've done a really good job of getting a large part of the family law bar here. But there's a good portion of folks that are just sort of getting involved now. And what I want to ask you guys to talk about, what would you tell newer lawyers to encourage them to not be terrified of family law and to actually want to take a pro bono case or come in and start a practice in that area?
Well, I mean, family law is kind of a unique practice because there is a statute that lays out a lot of the, I mean, it's not like just general commercial litigation where you have to kind of learn whatever area you're in. Family law, there's a statute. If you read the statute, read the rules, you'll get a good leg up on what's going to be expected of you. And if you get through that and you have a question, go to the annotated statute and you'll probably find the cases you need. One of the things you should do before you come to a hearing is, if there's an issue that's of particular importance to you, look at the cases on it, pull the cases, be ready to present them. Because as much as I think I memorize everything I hear, I can't remember as good as a piece of paper. So if you have a case that has the law, and lay it out for me and help me, then it'll help. Yes, ma'am?
I have a question. How, and this is unique to this practice, how do you handle that you're a judge in a court of equity that has its own rules and regulations and cases?
Hey, can you speak
Oh,
up just a
sorry.
little bit?
Never been accused of that before. I was asking Judge Fitzpatrick, when he sits up there, he's sitting in a court of equity, which means he has to make sure that everything is fair, and he's sitting there trying to help people. But the same token, there's a law, there's a rule, there's a myriad of things that make it black and white. And then you look on the other side, and on the other side of your road, it's gray.
Sure.
And so it makes it a very different kind of judgeship, I think. And that if you don't have a heart and you don't understand how things affect this family,
Mm-hmm.
I think that you're not doing your job.
Well, that's the eternal struggle that you have, because you have, one side saying, I got this case that's right on point, and the other one says, well, but you don't understand, this is different from that because of X, Y, and Z. And you have to be able to balance those factors, and that's, that's why they pay us to wear the black robe, I guess, to have to make those tough decisions. Because there's never a case where you go, well, this is an easy one. You guys are clearly wrong over there and clearly right over here. I mean, there's always some argument to be made, and that's why I count on you guys to know your stuff and get up there and make those arguments, because I am depending on folks to make sure that they present their best argument, so that when I write up this decision or this opinion, it's not going to be something that's going to be laughed out of court later on, and well, Fitzpatrick doesn't know what he's talking about.
But one thing you always have to keep in mind, like in criminal, one of the litigants does something stupid and you punish them for doing that. In family, just because one of the parents does something that's not very mature or not very smart, I mean, you still have to think about the best interest of the child in the long run, and not just do something to maybe punish or correct the parent's behavior that's going to hurt the child. So you're always having to keep that in mind. And one thing I thought of regarding new lawyers, I mean, one couple good things about family law is, one, you don't have to worry about a jury, so that makes it a little less stressful coming into a family law situation. And then in general, I mean, even though you certainly want to be familiar with the rules and the case law. It's a little more of a relaxed atmosphere than criminal, I would say.
Yeah, I always try to make folks as comfortable as I can. You know, I don't require you to stand and say, may it please the court and all that other stuff. And I'd rather have a conversation with everybody in the room about how we resolve the issues and figure that out if we can. And I'll start a lot of trials with, you guys are, 5% off on the visitation. One wants 45%, the other one thinks it should be 50%. And, can't we figure this out by adding another weekend and making it even? And you'd be surprised how many folks will sit there and go, yeah, we could probably do that. And, that'll eliminate half of the issues. And it's usually the tough issue of parenting decisions. So that's.
Well, I enjoyed family law, and I never thought I would say those words. But it gives you an opportunity to make a difference. And it's easy for me because even though I may get angry at a parent, I understand that my job is to deal with the best interests of the children. And I just try to dig away at these people who are sitting in my face saying these things and think about what is in the best interest of a child who's usually not even in the courtroom. And I think that for young lawyers, if you want to make a difference in the structure of our community, family law is just a good place to be because, it's the first community, which is the family. So you can make a lot of difference. You make a lot of money, too, in certain instances. But it's just
Please
a really...
tell us how to do
It's a very rewarding practice. I did criminal defense work, which is a grind, and family law is a lot different. I try to, when the folks come into the courtroom, I talk to the litigants. Most people who know me in the courtroom, the first thing I do is I talk to the litigants. The lawyers are the last people I really want to talk to, and I try to ingratiate myself with the litigants to see what it is. Talk to me, and I want to develop some kind of rapport. You can say things. You don't have to go through your lawyer because this isn't a criminal case where, you're going to blurt out a confession and there goes the case. I really want to know what you think, and I try to get, I remember I had this case with this couple. They would not talk, and so finally I talked to this couple. And I told them, I started talking to them, and before the case was over, they were talking to each other. I was like, isn't that cool? And, I really enjoy family because you can make a lot of difference, but it is very human, unlike a lot of other areas like civil practice, commercial. And I enjoy it. And let the record reflect that Judge Reynolds is in the back.
You didn't want me to recognize him, I'm sure. Well, does anyone, before I move on, does anyone have a question on this? Go ahead, sir.
Well, following up on that note, you all kind of said it's an more of an informal atmosphere for these family law cases. Does it get on your nerves if the lawyer is a stickler about the evidence, so to speak? There's always a fine line in being an advocate, but being, this report says what it says, and sure, if they got the right people here, they can probably prove that. Are you more of the types to say, just stipulate and let the thing in, let's move on with this, or?
No, and I'll let anybody state their objections for the record, obviously. But at the end of the day, it's not as though I'm going to be muddied by seeing something that's irrelevant, because I can ignore an irrelevant document. I'm not like a juror over there who's, once I've heard it, it's over. And I do juvenile cases as well, where the rules of evidence applied in the juvenile cases, we would have a very slow system, because normally what we have is two people, one saying, yeah, he hit me, and the other one saying, no, I didn't hit him, he hit me. Well, you go back and forth on that enough, there's probably all kinds of evidence problems. But in the family law system, I try, especially on the property sorts of issues, that's where I think you have to abide by the rules of evidence and make sure that if someone's trying to prove the value of something, they don't just get to throw a number on the board and say it's worth $10,000 where there's nothing to support that. But on parenting issues, that's where it's tougher, because you want to get down to the brass tacks. You want to find out, even if this is a statement that somebody said to somebody else, Is it true? I mean, that's the ultimate test. Is it true? I mean, did this kid have bruises all over his back or something like that? I want to know the truth about that. So that's a little bit tougher. You know, the rules of evidence are what the rules of evidence are, but the best interest of the child is the controlling thing over all of it. So I don't know if you guys have that same kind of battle on those sorts of issues or not.
I heard kind of two parts to your question. I don't know if I'm reading into it or not, but I think people should try to agree to stuff if they can, and not just waste time and be difficult. I think that helps your credibility with us if you agree to things that are obvious and can be agreed to, but I also think the rules of evidence apply. Like, I don't know if I think a couple of you might have been at the Earhart thing the other day. I think, Dana, you were there, and he's like, I don't understand when people say the rules of evidence don't apply in these certain areas of law. I mean, they definitely apply.
Mm-hmm.
Well, I tell you what, I have the only difficult situation I found myself in is people who don't do family law on a regular basis and do complex litigation. And then they come into the family court. It's like, whoa, these pleadings. That's a difficult situation. Somebody's just grinding that file out. And instead of just, this is a family case. It's not a patent case, you know. So that's a problem for me.
Before we move on, I'd like to add a couple of things. So what you guys have heard from the judges here today, obviously we have an extremely supportive judiciary, and so especially for the young lawyers that are thinking about taking a family law case pro bono, in addition to the warm fuzzy factor that we've talked about a little bit, and the fact that this is a practice area that always has a market in every city, county, town, anywhere in the country. There's always people who need help with family law, but also the Legal Aid Foundation here in town and pro bono organizations around the country provide support. So as a new lawyer coming in to a family law case, it can be hard to make that decision to take that case on a pro bono basis because you're worried about this niche area of practice that you have no experience in. Well, we provide an expert panel of family law attorneys who are experienced in that field. You can call them up anytime and they walk you right through exactly what you should do in your given case. Bibb Willis has helped me on innumerable occasions on different cases. I struggled with one case and sat down with Bibb and with the client on the other side, and we got it resolved in about 5 minutes. Sometimes it's just a matter of talking people through their issues, but rely on the resources that are available to you. You don't have to come into this thing blind or alone. Obviously, you want to be diligent and look at your rules and your applicable statutes, but when it comes down to how things are done, we've got resources available to you. And the good news is, once you do it a couple of times, you'll understand it, and maybe then you'll be in a position to take on a paying client in one of those cases.
Okay. Yeah, question.
I think one thing that might help the newer lawyers, in my opinion, because I'm not clear about this, I've been practicing for a really long time, really is like, I'm sorry, the local rules, whether, we have a administrative law book supposedly, but I think a lot of them are so ancient. They're either not applying. I know once years ago I mentioned one to Judge Caruso, he didn't even know such a rule existed, and I don't think he cared. But they used to talk about requirements to do a settlement conference before we did mediation. Nobody does that anymore. I don't know if that's still in there or not. I haven't looked at that, so that's one thing. I don't know if all young lawyers or where there is a book of local rules. And then second, I think the judiciary needs to make sure we know which ones are still in effect. The second thing, and I don't know that you guys can do that, that I think would be very helpful to people who are scared to do a family law case is if we knew what your common practice was. Like I asked Judge Fitzpatrick a couple weeks ago, you may not remember this, it would help us if we knew, so our clients maybe could settle, because our client wanted one thing, the other client wanted something entirely different. I think if we knew what your standard order might be, like on a fraction schedule, it would help. Maybe some of those cases wouldn't get litigated. And finally, I was told, I haven't looked at this, I did know that Pensacola had a standard schedule on their clerk's website that apparently they use. And another thing somebody told me recently, which I thought would be really helpful with this out there, I think one of my students actually saw it, was they have a standard order about, there's a standard order entered that there's not going to be anybody wiping out accounts and things like that. It's going to be frozen. And I think those kind of orders would be helpful.
Like 4 things we touched on there. Well, let's do one at a time here.
the first DCA, and I think the other DCAs frown upon standard orders, is one problem. I mean, the freezing of assets, I think you could maybe have a standard order on that, but as
Well, it
far
should be
as,
part of any temporary order. If you want that as part of the relief,
Yeah.
ask for that in a temporary order, and that would be
but like a
included.
standard time sharing,
Yeah.
that's no
That's
good. But I mean, I think we could maybe share our philosophy on it or something, but I don't think we could necessarily have a standard.
I hope you don't ask me to tell you my judicial philosophy, because still developing
You might
it.
get that at some point.
Still developing it, so you guys.
Well, let's talk about, you brought up a really good point there, Judge Fitzpatrick, about temporary orders. So let's talk about that for a minute. And you have the petition, it's filed, there's an answer, and now automatically now an order of mediation is coming out, it seems like. Is that true?
I don't do that until you guys try to get a trial scheduled. I'll let you do your
Okay.
work until you decide you're going to go to trial, and then I'll enter that mediation order. But I think, from the get-go, normally I want the parties to get together and enter into some sort of temporary agreement pending a final resolution. If they can't get an agreement on that, then I expect them to file a motion that says, motion for temporary order of, setting, whether it be child support, parenting schedule,
Okay.
temporary alimony, whatever those issues are. I don't require you to go to mediation to get the temporary order entered. I think that would put the cart before the horse.
That's one of the
but-
things I want to talk about. Does anyone else, the other two judges, do you enter an automatic order referring to mediation or anything like that?
I don't enter an automatic order, but I enter it sometimes after the case is a couple months old.
Yeah.
I go through all my cases every couple months and make sure something is happening on them.
So they don't sit
That's
stagnant.
good.
Yeah.
Yeah.
This is why we're here, y'all. So let's talk about it.
Well, to comment on the standing order, Walton County has one. And Walton County, much like FAR is doing with the presumption of 50-50 parenting that they keep putting in the statute, that has gotten huge grief because it's not always appropriate in a temporary order. But I do agree with the idea of something that just says, okay, here's what you're gonna do. The things that do help in that is nobody's clearing out assets, nobody's doing this, nobody's, the things that we come to you that are not child related. I like to think that all the attorneys I practice with in the family bar, we're usually pretty good at being able to get it down to, okay, we just disagree on what income is. All right, well, if that's the case, then let's set it for something quick, let the judge throw it at it. But on mediation, one of the questions I had about mediation was, and maybe I need to take this up with Dave, sometimes we get orders where we've already mediated, and it'll send us to mediation, and
If you've already mediated, just tell me you've already mediated. If you don't think it's going to be beneficial, I'm not going to send people back to mediation that are not going to go and have any.
well, yeah, I understand that,
Success.
Judge. What I'm talking about is sometimes they'll just get randomly generated.
Uh-huh.
Like Judge Dempsey saying where she's going through her files and finding stuff. But it used to be that, much like we talked about, not everybody is a underwater assets case, who's got the stock options
Sure.
and all that. And some people truly can't afford the attorneys, but they need the attorneys because they know they can't do anything. The case is going to be a nightmare if they don't have somebody guiding.
Sure.
Recently here with scheduling mediation, and I'm not sure if y'all have seen this from the bench side, we're told we have to have an order to use the courthouse, whereas before it used to be if they're under 100,000, it was an option to schedule at the courthouse. Have y'all seen any changes in that from the bench? Or is my question probably for Wilson?
No, that's probably a good question, and we need to clear that up, because the other day I found out Wolfson was generating orders without my knowledge, which I don't really like. So, I mean, just on mediation, not on other stuff, but still.
Oh, that's good.
But still, it's a problem because, like, the 75 days had already expired, and I was just ready to issue an order to show cause, and he entered another mediation order. So to me, I felt like he granted a motion to continue the mediation timeframes when he did that.
So
So I don't know, it's kind of seems like you should have to have an order, but I don't know. I mean, it doesn't matter. I'll look into that and think about
My
that.
experience is when I call Carol, she'll go ahead and schedule it. As soon as we grant a date, then an order
That's
gets
when they do
issued
it.
after that. But I will tell you, I had an order recently with Mark Walker's signature on it.
Okay, yeah, see, that's another reason why I don't, I mean, I like to
This takes a
do
lot for the family, doesn't it?
my own orders.
He's got a long pen.
Well,
And then also, we just like to have like, if you've already done a mediation and you want us to not require you to go to
File
mediation,
something.
like he would file something, because
So we mediated.
we like to
reached
have
an impasse,
everything,
or-
we like to be able to take up the file
Sure.
and everything be in there and self-explanatory.
And I know
That's
there's
very
several
helpful.
cases too where we'll go and we won't impasse, we'll just take a breather. So that everybody can go back and figure it out. And that's usually, that's
Adjourn.
usually, well, sometimes we call it adjourn, sometimes we say see you Wednesday.
See you Wednesday.
But that's usually when we'll get this order or something
Sure.
coming to us. And be like,
Well, I mean,
right.
in those circumstances, though, where there's still hope at the end of the tunnel, I'd
There's
want,
hope to, there's hope to.
I'd want you to keep that, well, sometimes even afterwards, so keep that door open and, try to resolve as many issues as you can. And don't worry about getting a complete and total resolution of the case. If you can resolve some of the issues so that you come to me and just ask me, well, the question is whether this car is marital property or not. I can answer that question pretty easily, But if that's the only question for the case, then that's a whole lot easier than having to deal with every issue when you guys are so close to reaching a resolution on them. So,
yeah.
But do you agree that in these low-level cases where we're not talking about stocks and bonds and trust funds, that the faster these people can get to mediation, the better off they are?
I mean, if we're talking about parenting issues, I think talking about the parenting issues is the only way you're going to resolve them. Because, a lot of times people are arguing for the same thing, they just don't realize it.
Exactly.
Somebody's saying that I want every other weekend plus a Tuesday, and the other one's saying, well, I'm not going to give you Tuesday. Well, the real important part is the every other weekend. So, I mean.
If you guys ask us to enter a mediation order, I'm pretty sure we will. But I think maybe they don't get entered for a couple months after the case is filed regularly.
I'm primarily talking about the really low-level cases, particularly where you've got one side is pro se, and the faster we can get someplace before, there's a lot of discovery, and there's a lot of demands for documents, and everybody's
Sure.
guts all tightened up because they think they're in big court, so to speak.
Right. Well, if you think, that's what I was saying. I mean, if you think we're taking too long on the mediation order on a particular case like that, I'm pretty sure all three of us, if you guys filed a motion for mediation, we would enter a mediation order. I mean, why wouldn't we?
Well, I was thinking about a routine order. We used to do that.
Well, see, I don't want to send you to mediation, though, if both parties don't think a mediation it's time for mediation. In other words,
Yeah, because
if-
other lawyers have told me they don't want it
yeah,
right
somebody
away.
says, I'm not going to go to mediation until I do discovery. Well, then I'm not going to send you to mediation before you do discovery. Now, in some cases, there's no need for discovery because
There's nothing to
husband doesn't have any money, wife doesn't have any money, and they're just fighting over how the kids are going to get split up or whatever. So that makes it different. But.
The other cases are the bar complaints.
Yes.
I saw a question in the back, Karen.
A comment in response to Rob's concern. I think what may be going on there is there could be considered a different level of judicial immunity for the mediator if it is court ordered.
That's true.
That's true. Good point, Karen.
That's
Yes,
almost
sir.
Good point.
Okay. Let me just follow up on it. So go ahead.
I think we badly need a standing order or part of the administrative, or part of the local rules. We need some sort of a local rule that addresses parties going into temporary relief hearings and having to provide their schedule of evidence and proposed witnesses. I have never come across any other circuit that does not have a standing order on that. So at this point in time, basically what I have to do is to send out an RFP and interrogatories to the other side all the time before temporary relief to ask them, give me your documents that you intend to use, tell me all the witnesses that you need to bring, because that you're going to bring, because if not, it's basically trial by ambush at the temporary relief hearing. And I think, and of course, the administrative judge for the family law section is here, and maybe I need to address that with him. But I think that's badly needed. because otherwise there are unknown people walking the courtroom nobody's seen before. Number one. Number two, if I may just go back for a second on the issue of general magistrates, and very respectfully, I'm not going to name names, but there's always a problem when a general magistrate puts down a report and recommendation in a stream of consciousness kind of form and does not identify findings of fact and recommendations for the judge. And it's just a narrative that may go over pages and pages and pages where everything's intermingled. And of course, the standards in front of your all honors to attack various things is different if it's an issue of fact or an issue of law. It prompted me at this point in time to just turn down any magistrate appointment because I know where it's going to end up, and it's very problematic. And it makes your job terrible, I think, because you don't know exactly how to parse things out. Thank you.
Yeah.
Let me ask, is anyone else concerned about that temporary hearing issue?
Having a witness and exhibit list or something like that,
really.
or
A little
Seems like
bit.
around the world.
Well, the question I have on that, though, because I was just about to go there, you had suggested get a temporary motion filed. Now, it's obviously something that usually you're going to need something on a quick.
sure.
You want to turn it around. Does having that need for discovery and all that slow that down, and how do you balance that?
I mean, I think the temporary order, a lot of times can be based on just the testimony of the two parties and their affidavits or their financials, because obviously if they're going to lie about their financials in their affidavit, then there's trouble coming down the road anyway. But you get those base things in. The parties are really fighting about temporary support and parenting issues. We're not deciding the value of assets. We're not deciding,
And I usually set those for an hour. I don't know about you
Yeah,
guys.
it's
So
not
I mean,
gonna-
I don't know how many witnesses.
It's not gonna be an
Usually you're
extensive
just going to
hearing,
be
yeah.
hearing from the two parties on relatively quick basis.
And just so I can kind of bring us back here a little bit, because I also want to make sure that the younger lawyers really kind of know what we're talking about, because this is kind of a technical thing in a way.
Sure.
All right, so for a younger lawyer that's handling a case, would you recommend that they've done their initial pleadings and that they would file a motion for temporary support?
Something of that
Is that
nature.
something
If it's
that-
necessary, yeah.
Okay.
Well, and especially if it's a situation where, you have one party works, the other party takes care of the kids. You don't have that order in place. A lot of times, that's just, I'll give you money when I think of it kind of thing. And that's not good for anybody. Because then later on, you have a huge arrearage where he hasn't been paying, he should have been paying $500 a month, and instead he's been paying $200 a month and been going on for a year. So, it's a big chunk of money. Most people, when they look at the numbers and say, child support says you're going to pay this much, there's not a lot of balking back and forth. That's what the numbers say, that's what the numbers say. But if it's a situation where there's going to be a terrible situation where someone may lose their home because they can't afford to pay for it because they haven't been receiving that child support on a continuous basis and things like that, so.
Yeah, I mean,
For
it's gonna-
everybody, welcome Judge Gievers.
It seems like it's going to somewhat depend on the facts of the case.
Yeah.
I mean, if it's relatively simple and it's going to get to trial in 6 months and the parties have an informal agreement that they can live with, then they probably don't need a temporary hearing. If it's going to take longer and one of the parties is being really unfair, I
Yeah.
guess, is what Judge Fitzpatrick was alluding to, then you're probably going to need a temporary hearing.
Let me follow up before I open it up again. What is in your experience right now, how quickly is the hearing turning around from the date that the motion for temporary support is filed, typically?
I mean, my JA sends out whatever we have available. You can get it scheduled sometimes within a week, sometimes within 3 weeks, but if it goes longer than a month, then something's gone horribly wrong.
Okay.
I mean,
Yeah, mine can get scheduled within a month.
Okay, great. Do you have any specific dates that you look for? I mean, of your week? Is that, or is it just any day?
well, my schedule's different than these two ladies. My schedule is, unfortunately, fortunately or unfortunately, I have the juvenile docket that swallows up most of my mornings. So I don't usually have morning hearings unless it's on a Friday. Or sometimes I try to squeeze one in before lunch if it's going to be an early day. So Fridays, I'm usually pretty wide open. Not many folks like to schedule things on Fridays, though. And then afternoons, except for Thursday afternoon, every other week I have drug court. So usually I'm pretty wide open most days of the week in the afternoon, and then on Fridays. The only kind of condition on that is Wednesdays are my juvenile trials, and the juvenile trials will sometimes run all day, and I can't predict that from week to week. So if you have an emergency sort of matter, sometimes I'll schedule it on a Wednesday afternoon late, because normally I'll get done with my juvenile trials around 2 or 3 o'clock and have the rest of the afternoon. But
I have a great practice art. I do not mind telephone conferences, and I do them on a regular basis. I do that. It may not fit with other judges, but me, if there's something that's going to take 10 or 15 minutes, and the lawyers, they generally know what they want to do in terms of the parenting schedule or whatever, I will say, Judy, get them on the phone.
Okay. How does everyone else feel about that?
I don't mind telephone conferences at all.
Judge?
I don't mind them, I guess, other than if you're going to have testimony, it's not.
That does make it
I
tougher.
don't do that.
Yeah.
But I mean, if there's a, the lawyers may know what it is that is appropriate, but they've got 2 clients that are acting, up and don't want to do what is right. And the lawyers will get on the phone and we'll have a conversation, and I say, well, I'm inclined to do this, and it's easier for them then to go back to their clients and say, this is what the judge said.
What would be the best way to structure that? Just pick up the phone and call your JA?
Well, usually if you follow, well, that too, a lot of lawyers have started picking up the phone. We need to talk to the judge for 5 minutes, and I will pick the phone up. But if you file a motion and ask,
Stay in there.
and say, we have a 15-minute telephone conference with the judge, I will tell her to pick the phone up and call. I mean, I look at it like this. I practiced for 20, 30 years, and I would appreciate that type of, don't get in my car, drive down here for something that I can do over the
A
telephone.
5-minute hearing takes you 45 minutes because you have to come to the courthouse. That's a problem. I mean, and I don't mind having those telephone conferences, especially where it's just argument or just somebody saying, we think it should be X, but it should be Y.
I'm thinking of it in...
I'll give you a good example of it.
Like competing orders?
Well, this is a good example. There was an argument over whether the tax deduction should be alternating. It took about 7 minutes to make that argument, but it would have cost them, hundreds of dollars, and probably eating up any benefit from any tax deduction that they were going to get coming down to the courthouse. So
Now we got a bill though.
I understand. Hey, and I think that's where you all have to decide. This is a small issue. We can argue about it, or we can present 3 witnesses on it, but it's really going to come down to the argument. And then you guys did a good job the other day. You had a hearing where you would have put on 7 hours of witnesses, and it wouldn't have changed the evidence much at all. There would have been good stuff and bad stuff, and they would have been fighting back and forth. And I would have had to listen to everybody talk about it, and it would have been a long day. But we were able to cut through it, get the evidence in. We still had the evidence, but we, didn't have to hear it 7 times from different people. And I do count on you all to do that for me. That and accurately predicting how long your hearing is going to last. Because if you tell me it's going to be an hour, and you got 9 witnesses, it's not going to be an hour. It doesn't matter if these witnesses are going up there to say hello. It's going to take at least, 20 minutes a witness or something like that. So,
Judge Gievers.
As you can tell, we all understand that we're here to serve, not just you, but your clients. And so we are mindful of that. And to the extent our other assignments make it easier or harder to squeeze in a telephone hearing, we're happy to do that. I also have the advantage of being in Jefferson County, and I've been there since April 1st, and I've already had some pro se folks show up over there who live in Leon and say, oh, well, the clerk over there told us that it would take 6 months in Tallahassee, but you could get us in sooner in Jefferson. And some lawyers are aware of that, Telephones are wonderful. I don't have a problem allowing Tallahassee attorneys appearing in Jefferson by phone if it's not evidentiary. If it is, that gets to be more of a problem. But if somebody sends in an emergency motion, I take you all at your word. Like most of, I think all my colleagues up here, anybody that's been in practice, you don't go throwing the E word around unless it is an emergency. And if you say it's an emergency.
I don't know if I'd go that far. Some people throw the E word around. But
Well,
There's a little E word, expedited, which is probably better than the big E word, emergency.
The lawyers that I've had the privilege of having in front of me understand that word as I understand it. So we've been on the same wavelength. If you tell me it's an emergency, whether it's having you come in at 7:30 or 8 o'clock the following morning or at 4:45 on a Friday,
and that's how
we'll
you tell.
get you that time.
That's how you tell if it's an emergency or not.
That's right. If you don't, so you could use that as your yardstick, as Judge Fitzpatrick suggests, but.
Because if I say you're going to be here at 7:30, you say, well, that's not really convenient. Then I say, well, it's not really an emergency.
And letters that come to us from individual clients who are represented by counsel saying the other parent's about to take the children out of the state, those are going to endanger children potentially and require the judicial assistant to scramble a telephone hearing, especially before a holiday weekend or a holiday,
That's exactly right.
Thanksgiving Day and a Friday, whatever. So you can see those kind of things coming with your clients. Give them some counseling not to do that, please. You don't need the headache. We're happy to be there. We'll have hearings wherever we need to, right, Judge Reynolds? So,
I saw some hands over here and even here, but we moved on a little bit. Does anyone have a burning question? With a room like this, there's got to be some questions.
I have a burning suggestion. Would you say that a good advice to a new young lawyer that's going into family law, that's starting to prepare for final hearing, starts on the first day? You give them a list of the documents they need to produce. You give them a blank financial affidavit. You start them on the road to preparing for a hearing. Now, if a temporary hearing comes up here instead of a final hearing way over here, they're prepared because they have all their documents together. I think that's the hardest lesson to learn in this kind of law, is that you have to start your client thinking of what they have to do to comply with the rules and get their stuff back to you and get it filed and get it to the other lawyer.
Sure.
And then if there's a temporary hearing that comes up, you're prepared. You don't have to wait a month or 2 months. Oh, well, let me get my client to get his document. I just think that's the best advice is to start on the first day.
And that's why you should be up here, sitting at the table.
and it's kind of envisioned by the rules.
I'd like for you to be responsible for making these decisions.
I will say that that's an excellent practice in my experience as I've taken a few pro bono family law cases. I get all the forms together ahead of time. If you take a case with the Legal Aid Foundation, they'll provide you with copies of all the forms. And the first time you meet with your client, you sit down and have them complete everything that you can possibly have them complete on that first day. And anything that they can't complete right then is going home with them, and you expect it back. Right.
Don't just fill in the blanks. Sign your name so that if I have to file this, I don't care if it's handwritten, your name is on there and you have signed it, and it's not like, oh, gee whiz, I forgot. Well, you know, it makes you look bad, not them.
That's right.
So, well, Judge, I know it's not signed, but.
I mean, it's helpful too if you explain to them the financial affidavit and what exactly that means. It seems like lately I've got a lot of comments like, oh, well, I thought that was going to be my budget after the dissolution, or I didn't really
Not
know
what I was
what
spending
that
today,
meant.
spend later. Or
It just seemed like people.
that's what I was hoping to get out of the divorce. $7,000 a month
Yeah.
for rent. That was all I was hoping for.
I mean, it might seem obvious, but I've been getting those comments
I think
lately.
you can make some assumptions if you explain your assumption. This is not the current rent, asterisk.
It's what's expected.
This is the rent
Sure.
of apartment at whatever
Sure.
that my client is going to rent next month.
You know, it's you know, you get.
Instead of just throwing it out.
You get, sometimes you go through those, and you guys all know this, when you start questioning somebody about where they came up with the numbers, and they say, well, it's, you know, the number I came up with, and you're going, so you don't spend $15,000 a month on food or, you know, stuff like that, and
Well, what Patty just said, and there was a lot of confusion for a lot of years over those financial
Sure.
affidavits. I mean, you look at them and go, and I still to this day think the greatest one is that they draw a $5,000 deficit.
Yeah, every month.
Everybody.
Every month we go $5,000 down.
10 months later, you go, where'd the 50 grand go? Where'd it come from?
How you spending that?
Oh, well, I'm not spending it. Well, that's okay if that's what you think it's going to be. One of the things I've noticed out of a lot of the attorneys in here, just because a form doesn't have it on it, footnote it. That is
Yeah.
the greatest thing in the world.
Yeah.
And I've dealt with some counsel here in this room where they will footnote something and then there is no.
Explain what
"Are
it
you
is."
lying?"
Sure.
Oh, no, that's what you're doing. Okay. Now, this is the marital home plus the apartment you're staying in.
Yeah.
You know, footnoting is so simple and it'll get through the confusion. And sometimes when one number's here and one number's here, you'll just bounce heads left and right until somebody goes, oh, well, I didn't know I was supposed to do it that way. Asterisk.
Yeah, there you go.
Kristen?
Touching on financial affidavits and temporary hearings and I guess a he said, she said situation, what or how do you really balance each person's testimony, especially when they're kind of wobbling over smaller amounts, not something that's obviously considered a $5,000 deficit,
Yeah.
but maybe someone saying that, well, I provide an additional this, much in child support every month, and the other party saying, no, you don't. But what do you do, especially in a temporary hearing where you may not have all...
Documentary proof is always good, like copies of checks, bank statements that say this much money went out or this much money came in, those kind of things. But, when you're making those credibility judgments, when you hear one party say, I sent them $500 last month, and the other person says, no, they didn't send me $500 last month. You might be able to get fool me once kind of thing. You'll be able to get past it the first time. But if you come back in the second time and say the same thing, and the wife said, I don't have the $500, I never received the $500, then you start losing that credibility, and you only have so much credibility. And once you start cutting that up, you're gonna have a hard time convincing me afterwards that yes, in fact, my car payment is $6,000 a month, and, something like that.
I think that's what you tell your client.
Yeah.
Day one. You keep receipts, you keep canceled checks, you give me your bank statements, you show me where you paid, what you paid.
Where that money
for
went.
your wife
Yeah.
and for your children. And if you paid the tuition in private school, where is it?
Yep, exactly. Yeah.
We have about 5 or 6 minutes left, and I had wanted to get to domestic violence because I know that a lot of younger lawyers that I speak to just don't want to get involved in a case that has that. Can you give us some advice on, or basically dispel the fears if you can?
Well, she's probably got.
Step one, I am blessed to have 4 domestic violence dockets a month.
Blessed.
Blessed, that's right, because it is the most basic kind of judging there is. Mostly, there are not very many attorneys that show up downstairs in 1B. So if you are an attorney on a domestic violence case, and there's 5 kinds of injunctions, we just use the phrase domestic violence to include them all, please let us know if you're going to have more than 1 or 2 witnesses. We'll give you a special setting. That will avoid the docket getting totally jammed up for all the pro se people that wouldn't know the evidence code from some other kind of code. And it will keep you from going crazy. I think we all try to take attorneys first, recognizing that you're generally at least double booked. But at the same time, if you're going to have a lawyer on both sides and 4 or 5 witnesses, and it's going to be an hour to 2 hours, you do not need that on the mass docket. Those are for straightforward, here's petitioner, here's respondent, where you can tell if it's a college roommate for the first time and you don't get along, or it's a baby mama situation and the daddy is nowhere to be seen and the mamas are not getting along. There are a certain number of cases that show up a lot, and they all can be serious and need injunctions, but generally the cases that have attorneys are different and don't fit as easily into cookie cutter shapes. So please do yourselves and your clients and us a service and let us give you a special setting. If there's somebody on the other side and an attorney on the other side, we'll make it as if we can't get it exactly within the 15 days provided by statute, we will come really close, and if you can agree to go a day or so over to accommodate that, we'll do that.
Are you suggesting before the return hearing?
Absolutely.
Okay, because at the return hearing, if it looks like it's going to take a while, I will say, go upstairs and get a special setting.
Can you explain what you mean by return hearing?
When it, the 15, the first hearing, the hearing on the final injunction.
There's a temporary injunction in place, or there's a hearing scheduled on a request for a temporary injunction. That hearing has to occur within 15 days.
Right.
Okay. Well, if there are two lawyers show up, and I will ask them if it's going to take a while. If it is, I will ask them if they mind going a special setting, leaving the temporary in place, and reset it. So as not to back up on the docket, because I don't like that either. It gets to be a little complicated if there's an order setting hearing versus a temporary already in place, because you really need to hear it to see if there's some life or death situation going on. But if there's a temporary in place and there's two lawyers on the side, or even if there's one lawyer and a whole bunch of on the other side, I'll tell them to go upstairs and set a final hearing.
One thing that I would just suggest, if there's a parenting issue involved at all, there's a request for temporary parenting plan or something like that, I don't want to have to decide that question in a 20-minute DV hearing in front of 35 people waiting out there who are not going to, they don't want to participate in that proceeding, and the people that are testifying are talking about personal things, and I don't enjoy having folks air their dirty laundry in front of hundreds of other people. Sometimes, I guess there's probably 100 people. But I think if you have a parenting,
I only have one group in there at a time.
Oh, really? See, I make them air their dirty laundry if it doesn't. but if it's a parenting issue, what I'll do if it's done on a temporary basis, I'll normally only make it last for the parenting plan for 60 days or something like that. If you all are going to have something longer than 60 days on the parenting side, then you need to get in and do your petition to determine, paternity, or your dissolution of marriage, or do something else so that parenting plan can be more permanent and heard by one of us in a more extended hearing than that 20-minute DV hearing.
Yeah, because although lawyers don't do it as much, unfortunately, some people use it as an eviction proceeding or a dissolution proceeding, and it's not.
It's like the first step in that dissolution. Well, you're like, well, the first step should be filing your dissolution petition, and then we'll proceed to the
I will add really quick that if you end up with a case that involves domestic violence and maybe you didn't know about it to begin with, the Refuge House has an office in the courthouse here, first floor. Send them over there. Refuge House can get your client who may be in danger, appropriate place to go, all of that stuff. That's not really your job as an attorney, and these people are trained to do that kind of stuff.
And they do a good
take
job.
advantage of
They
that.
do a good job in the domestic violence.
What's the best way to deal with the issue you brought up, Judge Gievers? You represent someone who's got a hearing coming up. What if you don't know the other side has a lawyer, but you know you're going to bring some witnesses? What's the best way to do that? Is it to call your JA or to file something, or?
You can check with the clerk's office to find out which judge is presiding over that particular docket, morning or afternoon, and whatever day of the week. And then just call the JA about getting a specially set hearing time. The key is we need to be able to give notice to the respondent not to waste their time coming to the courthouse for the mass docket. I can't tell you how many times we get motions to continue the hearing, and there's no contact information for respondent. Well, we can't grant a continuance. We know people will have driven in from out of town to be there because that's what time they were served with the papers and told to be there. So make sure if you're representing a petitioner to include contact information for respondent so we can get an okay to move the date to a special set time.
And just because I want to respect the judge's time and your time, that's our conclusion of our allotted time today. If you have any questions, hopefully maybe one or two judges can stick around. Come on up if you have time. If not, and I know there's going to be a happy hour. We have to change the location to 101. Okay, so
it's right next to Harry's.
Near Harry's.
The restaurant.
Yes.
Oh, I thought you had a room in this.
No, we don't let alcohol in the courthouse. Strictly forbidden.
So again, it's at 101 over near Clayman Plaza. We're going to go over there. I don't think the judge is going to be able to make it because they have a judges meeting tonight. So we'll be able to really have a good time. Okay? So thank you all for coming, and again.